Hello, and welcome to Money Mystery No More. Walking our dog recently, I began wondering what happens with all our bills, debt, and money when we die. It intrigued me enough to create one video, Estate Planning and Debt, and now this video to address estate planning and money. If you don't wonder about this stuff, it's no surprise because death is uncomfortable for many people to talk about, but avoiding the topic does not help. Estate planning done right can cause peace of mind for you, your family, and your intended outcomes. To really benefit and get the most out of this video, embrace the information involving your estate planning and money by keeping it simple. It's awesome. And remember, hit that subscribe button to keep getting the latest and greatest information. Okay, let's remove the mystery. In our prior video about debt, we talked about the meaning of estate planning and its importance. Whether you have $10 or $10 million, you have assets, which in turn means you have an estate. Your estate is the total of all your possessions and assets that you value, even if others don't. Ranging from your photos, jewelry, a chair, a car, or some boots, those assets are yours, a part of your estate. When you die, those assets need to go somewhere. That is what estate planning is all about. You get the ultimate say on who gets your assets, what happens with your assets, what happens to you if your health or mental capabilities go bad, and how all those things happen legally. Estate planning is about honoring your wishes. Your assets and affairs will be handled and distributed the way you want if you can no longer handle them or if you die. How people approach their death and follow-up details does matter. They can be aloof and uninvolved, basically not caring what happens. They basically say, let them deal with it, not my problem. They may be over-involved, which is the complete opposite. This person just worries too much about all the I's to dot and T's to cross. They want it perfect. Then there are those somewhere in the middle. They take an honest, good effort and responsible approach to it. Basically, do the best they can. Estate planning really needs to be done though, so it's less confusing, frustrating, and stressful for those grieving and left behind. It starts with the walkthrough of your home, storage container, garage, or other dwellings. The purpose is to record a complete and thorough list of everything you own, which will be considered your estate's assets. With that list, planning begins by documenting what you want to happen with those assets, along with your future personal well-being. Financial decisions is a broad subject, but we covered the debt side in our prior video. Here we'll focus on your income and money, not the debt. Your estate planning can dictate what happens with your money basically through asset transfer. Remember, asset transfer is basically you legally directing your assets to specific entities or people in a lawfully binding manner. Done properly, your intentions are handled through a will, living wills, trust, or other established designations. Because we covered asset transfer in depth during Essential Estate Planning provides peace of mind, let's just recap it here. Your plans become reality by having a will. That legal document dictates who gets what when you die. Someone is appointed by you as an executor to be your legal representative and act on your behalf while directing your assets to the people or entities you previously chose. A will needs to be prepared properly because it must be processed through probate with the courts involved. Your executor distributes your assets only, not jointly owned assets, the way you designated in your will. The will also appoints guardians of your minor children or dependents. If the will is not properly prepared, the public probate process will be a money drainer, a time drainer, and a headache for those involved. To avoid probate, many people utilize an asset transfer known as a trust. Think of a trust like a safe or a lockbox to hold your assets. Only the designated trustee has access. All assets contained within that safe are distributed to your desired entities or beneficiaries as you dictate through the provisions established in either a revocable living trust or an irrevocable living trust. In both cases, your assets are moved outside of probate. However, you control your assets prior to your death with a revocable trust, whereas you basically lose all control of your assets even while you are living with an irrevocable living trust. There are pros and cons with each. You may be familiar with an asset transfer known as a beneficiary. Jointly owned assets typically require a beneficiary be designated in the event of your death. These usually include retirement accounts, life insurance policies, annuities, some stock instruments, and even HSA accounts. Monies from these type of assets are passed from the financial institution directly to your named beneficiary and may bypass probate. Your desired beneficiaries must be updated, especially with life changes. For example, if you have a spouse listed on all of your financial accounts but end up divorcing, then remarrying, you may want to assure your beneficiary is updated. You can also gift your assets. Gifting during your lifetime may reduce your estate while offering some tax advantages to the recipient. Let's clarify now what is actually involved with probate. The standard steps are: 1. The probate process is initiated by the executor, or an interested party will file the state's required documents along with a petition for probate of will. 2. Once the court takes up the matter, the estate is opened, and they will seek the will to then appoint the executor. If there is no will, the court appoints an administrator. One of them will oversee the estate's assets being distributed. 3. An inventory is done of all assets. This includes any account that does not have a direct transfer, such as a beneficiary or joint owner. 4. As mentioned in our prior estate planning video, the executor or administrator will pay off all of the estate's debts with the estate assets. 5. Any assets left over will be distributed according to the will or state law. And finally, 6. After all of that, the executor or administrator will petition the court to close the estate. If that process does not bother you, having a will might just work out fine. Are you seeing the importance of a will, the executor, or administrator with the probate process? How your assets are handled depends on the type of accounts involved, whether there is a will, if there are beneficiaries or joint owners, and who is going to actually oversee how those assets are distributed. Not preparing for these factors may result in your intended outcomes not being honored. For example, you may have intended for some part of your money assets to go to certain causes or people, but if they are not a designated beneficiary or other legally authorized person, they will be prohibited from accessing your assets and funds. The executor or administrator will be required to provide legal proof to institutions if they attempt to make withdrawal. A beneficiary or joint owner isn't bound in that manner and doesn't have the same hurdles. A court will issue the power to an executor or administrator that allows them access to funds. Then the money must be transferred as per the will. Absent that will, monies are handled per state law. As mentioned, upon your death, if your bank account has a joint owner or beneficiary, the process is streamlined. If there is a will, the state executor may also have it somewhat easier. If not, the account, as an asset, will likely be deemed part of your estate, or the state will handle it through the probate process. There are a few more items to know about estate planning and money though. Take life insurance for example. This type of account almost always requires at least one beneficiary. The distribution will be released upon proof of the policyholder's death and should not go through probate. Depending on everything going on, those monies can really help your designated beneficiaries. Perhaps they can pay for your burial expenses or offset taxes, fees, or costs dealing with the sale of your assets. Or perhaps they can benefit in a greater way that you hoped for by listing them as a beneficiary in the first place. Another account that will not go through probate are joint accounts with rights of survivorship. These grant the surviving account holder full ownership of the account, regardless of who put money in it. The surviving owner gets to keep using the account with no interruption. If the rights of survivorship are absent, your share in that account might be put into probate for resolution per your will or state law. Also note these joint accounts with rights of survivorship are not subject to creditors because funds in a jointly owned account are typically not considered part of the deceased person's estate. And then there are beneficiary accounts like a POD, payable on death accounts, and a TOD, transfer on death type designation. The accounts and funds in them will also bypass probate and transfer directly to your named beneficiaries upon proof of a death certificate. A POD and a TOD type of account with the beneficiary is a contract between you and the bank, so it allows you to designate who gets that money upon your death. Without such designations of your account or a will being present, the account is normally added to the estate to be handled through the probate process. That account will then be frozen until probate works through its process. Oh, one more important point about banks and your account. If by chance the bank doesn't learn of your death timely and the account has no activity, the bank may give your funds to the state government through the process of escheatment. Obviously, estate planning and money is critically important for how you want your bank account funds given out. Remember, you can gift money too, but really, having a properly designed will is a fundamental to do. Fortunately, there are plenty of lawyers, professionals, and bank estate services available to provide you help. You see, your estate is your legacy if you desire. Estate planning done right can provide the path and direction for the authorities, your executor, trustee, administrator, or those bound to legally handle your wishes the way you planned, wanted, and intended. At the end of the day, you can provide peace of mind for you, your family, and your intended outcomes by designing a plan that works for you, by keeping it simple. Remember, hit that subscribe button, turn on notifications, and keep getting the latest and greatest information from Money, Mystery, No More. I'll see you in the next video.